Hi, everyone. My name is Lauren Ramos. I am an associate attorney at McGuire Woods, and we wanted to thank you all for joining us today, and we're going to go ahead and get started with the webinar. I'm also joined by my colleague, Edwin Smith, who is also an attorney in the healthcare department at McGuire Woods. We are presenting to you today a presentation on HIPAA business associate agreements. So that's where we'll spend the bulk of our time today, but we are going to start and end with a little more general information just about business associates, what's required of business associates, and kind of how they're now accountable under HIPAA to hopefully give some context around what business associate agreements really mean and what's required there. I know that we have the Q&A feature enabled, so please feel free to shoot your questions over. We will try to answer them in real time, and if we're not able to, we'll get a report and we'll certainly follow up with you after the webinar to respond to any questions that we don't get to as we're actually presenting. So I am going to go ahead and kick it off. And we're going to start out with what is a business associate? And so as most of you probably know, we've had HIPAA around since 1996. It's been around for a long time. And then we had the HITECH Act. That's been in place about 5 years now. That came in and made some changes to the HIPAA regulations. One of the big changes that was made was to change the definition of a business associate. And now business associates are actually directly liable under HIPAA. And OCR has direct authority over business associates to monitor their compliance, to enforce the HIPAA requirements against them, and to enforce penalties if OCR feels that a business associate has violated HIPAA. And that actually informs now some of the negotiations of business associate agreements that we'll talk about later, because that direct liability can take some of the pressure off covered entities to really monitor their business associates and bear the risk of using business associates and disclosing protected health information to them. So there's a two-part definition of what is a business associate under HIPAA. So the first thing is that you have a covered entity involved, which may seem obvious, but we get all kinds of things. You'd be surprised. So a person who, on behalf of a covered entity, creates, receives, maintains, or transmits PHI for a healthcare-related function or activity regulated by HIPAA. And you can see some examples here: claims processing, quality assurance, benefit management. So that is something that is, directly related to the health care of the covered entity. And just to back up a little bit, a covered entity would be a provider or a health plan or a clearinghouse. So if you have that relationship and PHI is disclosed or the business associate creates PHI on behalf of a covered entity, you have a business associate. They can also be providers of professional services. So, for example, we at McGuire Woods are, in some instances, a business associate to our covered entity clients because we, in some cases, need to review PHI in order to provide legal advice to our clients related to their some issue that they've had come up, or maybe a HIPAA breach. And this can also include the covered entity's accountants, accreditation services, their auditing, anything like that, where the provider of professional services needs to access PHI or may even create PHI on their behalf. A business associate does not include members of the covered entity's workforce, and this is an important distinction because workforce is not necessarily just formal W-2 employees of a covered entity. The definition of workforce is much broader than that, and it's basically anyone who is under the direct control of the covered entity and performing their duties. So sometimes you have that relationship without necessarily being an actual employee of an entity, and in that case, the workforce member or entity that's considered a part of the covered entity's workforce does not constitute a business associate. You don't need a business associate agreement. That workforce member is just expected to follow the covered entity's policies and procedures and all of their protocols, and the covered entity is responsible for training those people and basically takes on all of the liability and the requirements with respect to that person or entity as a member of their workforce, and they are not a business associate in that case. So we get confusion in these cases. And then the other one that gets a little bit confusing, and I think we'll get to in a few slides, is sometimes just because there's PHI involved or being disclosed, it does not mean that there is a business associate relationship. You still need a permitted reason to disclose PHI to a business associate under HIPAA. Calling someone a business associate and putting a BAA in place does not necessarily mean that you're in compliance with HIPAA if there's not a permitted reason to be sharing your PHI with that business associate or with that entity. So we get a lot of real-world kind of guidance on this from OCR, who are business associates and who aren't. And so this was an interesting example a couple years ago. There was a lot of debate for many years over whether, as cloud services have grown so much and the use of them, we've seen a lot of confusion, and there's a lot of debate about whether they should be considered business associates because, realistically, they're not really doing anything with PHI. You, as a covered entity, put your PHI in the cloud. They just provide the server for you to store it there. So there is, an argument there that they should not be considered business associates that have responsibility with respect to that PHI. OCR has come out and taken a different position. As you can see, then they confirmed that they are cloud service providers. They have duties and obligations under HIPAA, as do the covered entities who use cloud service providers to store their PHI or to transmit PHI, to share PHI maybe with another covered entity or with clients or whatever it might be. You do need to have a BAA in place. You have to treat them exactly the same as you would any other business associate. So this is just a good example of how far-reaching we're getting now with business associates and that definition. So the Omnibus Final Rule of the HITECH Act that expanded all of this to include direct liability for business associates said we estimate that each new or significantly modified contract between a business associate and its subcontractors will require 1 hour of a lawyer's time at a cost of $84. And so I'm sure all of you are giggling a little bit because none of us know any lawyers that only charge $84 an hour. So we've gotten a lot from OCR as far as this won't really make a big difference for business associates. They should have been doing some of these things all along. There should be BAAs in place, whatever the case may be. And we find out that actually it's not just about modifying a contract. BAAs now have to directly comply with many, many provisions of HIPAA. And so these next few slides just kind of walk through those. What is actually required of a BAA? You have to comply with all of these regulations that are listed here. They're subject to investigations. They're subject to audits. They have to report to OCR. They have to provide compliance reports. They have to open up their books and records to OCR, not just to monitor their own compliance, but to investigate the compliance of the covered entity that's involved in the relationship. They may have penalties. We'll talk a little bit later about some specific examples where business associates did have penalties imposed on them. They have to be very careful with how they treat their employees and their workforce with respect to PHI and enforcing HIPAA compliance. And so you can see all of these requirements. Have to comply with all of the security rule requirements. So business associates need to do a HIPAA security rule risk assessment. That is not optional. You have to put your safeguards, your security safeguards in place. You have to address any vulnerabilities that you identify and have strict security protocols in place that protect the PHI that is maintained or created or received by the business associate. You can see all of these examples here as we kind of go through the slides. Many provisions that business associates now are directly liable to comply with. So the cost and the liability actually did increase fairly drastically. And the things we would look for if we are advising a business associate on complying with all of these requirements that they have to do is to put into place privacy and security policies and procedures. This is something that we do on a regular basis for our clients. It's very important to tailor them to the specific operations of your entity or of the business associate. You need to put in security policies, which are actually even more specific to the entity, because the security rule clearly says that you can tailor your security safeguards to the size and complexity of your organization. And then to have actual comprehensive compliant security policies, you need to address things like your specific mobile devices that your entity uses and your employees use, all of your specific computers, workstations. What is your physical environment like? How do you protect that? All of these kinds of things. So that is even more specific to your entity. And having sort of stock form privacy and security policies and procedures on the shelf that you never really paid attention to or customized for your entity will not fly if you end up having a breach or having an audit. So that's a really important thing to spend time on the front end so that you don't get caught on the back end for not complying. One of the biggest things that we tell all of our clients is just to use encryption. It's not technically required by HIPAA, but it's so standard now, and it's pretty low-hanging fruit. And if your PHI is encrypted in a manner that's compliant with most of the standard security standards out there, then most likely it's going to be considered secured PHI. And even if it is accessed improperly, you will not have a breach because a breach requires unauthorized use or access of unsecured PHI. So encryption helps you achieve security compliance, and it also can help you avoid having an actual reportable HIPAA breach should something go wrong. So we have some more just kind of guidelines here that you all can see, and we won't go through every one of these, but you want to make sure that you have all your breach policies in place. If you have an incident, you want to always be referring, as a business associate, always be referring back to your business associate agreements for what you need to do to be in compliance with those, because as we'll talk about, you can vary a lot from the actual HIPAA requirements. A lot of BAs add a lot of additional provisions, a lot of specific timing requirements that aren't necessarily under HIPAA. So you want to be sure you're really keeping tabs on what your requirements are there in addition to just under the regulations. Training employees, and documenting all of these things, all of your compliance efforts. Doing self-monitoring auditing, again, if you just put some form policies into place and put them on the shelf and you never revisit, you never update your security risk assessment, anything like that, you know, you're not going to fare well with OCR if it comes down to that. You want to focus on the high-risk areas. So these are things that we see coming up over and over and over again in the enforcement actions and the settlements that OCR publishes to the public. So many lost or stolen mobile devices that were not adequately secured but did either have PHI or could access PHI through the mobile devices. People like to talk about their high-profile patients, and sometimes we'll see a breach where somebody, you know, a covered entity or a physician or one of their contractors will mention somebody because they're high profile and that they received X treatment, you know, and that's an improper disclosure. And disposing of PHI, there are strict rules you need to follow to make sure that PHI is properly destroyed, and you absolutely cannot just throw it in the trash can or take a bunch of boxes to the dumpster, and there have actually been settlement actions involving those kinds of activities as well. Follow up promptly if you find any problems. So again, just the continuous monitoring, auditing. If someone alerts you to a problem, address it at that time. And make sure that you create an environment where your employees, your staff, your workforce feel very comfortable raising concerns about HIPAA-related issues or bringing up potential breaches without there necessarily being repercussions, because the liability and the risk is just too great for an organization to have their employees uncomfortable with that. So that's kind of an introduction to business associates. What is a business associate? What do you have to comply with? How do you comply? And now we'll get into, slow down a little bit and get more into the actual business associate agreements. So a couple of high-level thoughts here. A BAA is required between a covered entity and each business associate agreement. So there should be, in each business associate, sorry, there should be a separate contract with each business associate. And if any of them are, the fact that you have 10 BAAs in place, but you're missing number 11 that you really should have, that's still, you're still out of compliance. That's still a problem. And same with business associates and their subcontractors. So HIPAA explicitly says that if you are a business associate and you push down some of your responsibilities to a covered entity, to a subcontractor, they are actually also considered at that point business associates under HIPAA if they receive PHI, and you also have to put a business associate agreement in place at that level. And that goes on and on and on. As long as the trail of PHI is continuing on, there needs to be business associate agreements in place at each level. That being said, business associates have liability even if they don't have a BAA. So you can't say, well, a covered entity never made me enter into a BAA, so I don't have to worry about any of this stuff, and I don't have to follow the HIPAA regulations and protect the PHI. That is explicitly addressed in the Federal Register when the new regulations came out in 2013. If you meet the definition of a business associate, you have to comply. So when do you need a BAA? This is a tricky question that comes up for us a lot. Anytime a covered entity discloses PHI to a business associate, or like I said, if the business associate is creating PHI on behalf of the covered entity for some reason, or just maintaining it like a cloud service provider, that's considered a disclosure, and you need a BAA in place. It must be in place before PHI is disclosed. So backdating a BAA is not encouraged. You want to make sure that BAA is in place, that as a covered entity, and I guess I should take a step back to say this liability is really on a covered entity, to make sure its business associate agreements are in place. The covered entity will be the one liable to OCR if it's discovered that they don't have one. So it's not the business associate's responsibility. Having a BAA in place, like I said, does not create compliance if there's not a permitted reason to disclose the PHA. So you can't just go to your neighbor and disclose, have them sign a BAA, and then tell them, say you're a physician, and then tell them about all of your patients. You do not have a reason to disclose that PHI that is permitted under HIPAA. And so putting a BA in place doesn't help you. This comes up most commonly in diligence with transactions, I would say, because so often the buyer wants to see PHI for some reason as part of diligence, or they want to have their consultants looking at things, diligence that involves PHI. And there is a transaction exception under HIPAA that allows that under healthcare operations if you meet certain requirements. And I would say the majority probably of transactions, at least that we handle and in the healthcare world today, do not strictly meet that exception. And putting a business, and so often we get clients who just say, well, let's just enter into a BAA. That likely mitigates your risk and your liability a little bit, but it does not automatically mean that you are compliant with HIPAA at that point and that you're allowed to just go ahead and disclose PHI because you didn't otherwise have a reason that is explicitly permitted under HIPAA. So we talked about business associate now includes subcontractors. So if you're a business associate and you use a subcontractor who you disclose PHI to, you need to have a BAA in place. And you also have to comply with the agency rule, which basically says if a business associate is carrying out a duty of the covered entity as its agent, so an example of this would be distributing the notice of privacy practices for the provider to patients in the correct manner, getting the correct acknowledgement that they've received it, and all of that. So in that case, that's actually the covered entity's duty under HIPAA. If they have delegated that to a business associate and the business associate is then acting as the covered entity's agent, they have to comply with all of the requirements of HIPAA that would apply to the covered entity in that case. That language now explicitly has to be in a business associate agreement between the parties. One thing that came out in the omnibus final rule, but we still see a lot, is that parties do not have to report to the Department of Health and Human Services if a breach of a BAA cannot be cured and termination is infeasible. So the flip side of that is that it used to say if there's a breach of the BAA, terminate the BAA, which we see in all our BAAs. If it's not feasible to terminate the BAA, then you should report that to the Secretary of HHS. I suspect that the Secretary of HHS decided at some point they didn't want to get all those reports anymore. And so that requirement was dropped. However, it was a carryover. It was in, I believe, the interim final rule and then dropped in the omnibus final rule. And so a lot of people had already updated their BAAs to include this requirement, this reporting requirement. And we strike it because why do you want a reporting requirement in your contract if you don't actually have to do it? So that's one to look out for. And And then the key prohibition now with respect to business associate agreements is that the BAA cannot authorize the business associate to use or further disclose PHI in a manner that would violate HIPAA if the covered entity did it. So a covered entity essentially cannot go around authorizing its business associates to use PHI in some way that's not actually allowed under HIPAA. You cannot expand the permitted uses under HIPAA just because it's your PHI as the covered entity. So you should get to decide who can do what with it. That's not how it works. And often we actually see this language included in BAAs to say the covered entity will not ask the business associate agreement to do that, and the business associate to use PHI in some unpermissible way. I am going to now turn this over to Edwin and let him get into some of the nitty-gritty of what do we have to have in a BAA, and then what are we allowed to have in a BAA, and then we will get into some of the really, as we call them, hot topics, some of the really heavily negotiated areas of BAAs.
Hi, I'm Edwin Smith. I am a healthcare associate at McGuire Woods as well. And we're going to, as she stated, we are going to discuss the required provisions of a business associate agreement. First and foremost, the agreement must establish the permitted and required uses and disclosure of PHI by the business associate. It must also prohibit the business associate from using or disclosing PHI other than what's permitted by the BAA. And this includes using the minimum amount necessary for the disclosure. Also, business associates are required to use appropriate safeguards, including complying with security standards and to prevent use or disclosure of PHI other than as provided by the agreement. The business associate is also required to implement administrative, physical, and technical safeguards that protect the confidentiality, integrity, and availability of all electronic PHI that is created. This includes requiring the appropriate and necessary software, and also having physical and security barriers. It's also required for the business associate to ensure that any agent, including a subcontractor to whom it provides PHI, agrees to implement reasonable and safe and appropriate safeguards to protect the PHI as well. Business associates are also required to make reports to the covered entity when necessary. This includes when there's a security incident of which the business associate becomes aware of. This does not include simple pings like when, for example, when a member of their workforce forgets their password and types in the wrong password, and a security alert is issued for simple things like that, or attempted breaches that don't happen or that don't expose any PHI. Also, business associate agreements business associates are required to also make reports for breaches of unsecured PHI to the extent possible, and must identify each individual involved and other information so that the covered entity can provide notice within 60 days. There's some argument out there on how quickly the business associate must get this, or the covered entity must get these notices out. Since the business associate will be doing investigations, a lot of times they want to have as long as possible to report these incidents to the covered entity, but the covered entity likes to cut down on the time allowed. So you'll see a good struggle there, but the covered entity, in my opinion, is usually allowed 60 days from when they got notice from the business associate. But you'll see a struggle around there. The business associate is also required to obtain written assurances from any agents and subcontractors to whom it provides PHI, or who creates or receives by the BA on behalf of the covered entity, agrees to the same restrictions and conditions that apply to business associate with respect to such information that is received. I like to change this to at least the same restrictions, so that way it allows the flexibility to have harsher or more stringent restrictions into the agreement with the subcontractor. Business associations are also required to make PHI available upon request and in accordance with 45 CFR Section 164/524. Business associates are also supposed to make available PHI for amendment and incorporate amendments to PHI in accordance with these sections. This does not require the business associate to make all changes or all amendments that are requested. It's only required that they make appropriate changes that are requested. Business associates are also required to make available information required to provide an accounting of disclosures to the individual. Business associates are also required to meet the requirements of the privacy rule if it has to carry out any of the covered entities' obligations under the privacy rule. Business associates are also to make its internal practices, books, and records relating to the use of disclosure of PHI received from or created or received by the BA on behalf of the covered entity available to the Secretary of HHS. A lot of times the covered entity likes to put in provisions that sort of broaden these audit rights to include more than just the practices and books related to the PHI. You'll want to limit that because, I mean, that's sort of inappropriate for what's going on here with the business associate agreement.
And Edwin, I'll just jump in for a second because there's usually some confusion about this one as well, because previously this provision of the regulation said that the business associate had to make its practices, books, and records available to the covered entity or the secretary for these purposes, and the covered entity portion of that was struck in the omnibus final rule. So a lot of times we still see that language in there, and then as Edwin mentioned, even expanding that audit right beyond that, but that is a very small nuance between the prior regulations and the omnibus final rule that we often get tripped up on, and covered entities, will sometimes use to try to sneak in a little audit right.
The business associate, at the termination of the business associate agreement, must return or destroy all PHI which is received or created on behalf of the covered entity and retain no copies of the PHI. There is an exception. If return or destruction is infeasible, then the business associate must extend the protections of the business associate agreement to the PHI indefinitely. Oftentimes, the covered entity would like to have some sort of rights to determine whether infeasibility is if the return is infeasible or not, or the destruction is infeasible or not. And a lot of times I like to strike that because that can be a fight. Also, the business associate agreement must authorize termination of the business associate if the business associate has violated a material term of the agreement. As far as permitted provisions are, the business associate is permitted to use PHI if necessary for its proper management and administration, or to carry out business associates' legal responsibilities. Although this isn't required, this can be a deal breaker for a lot of business associates if they need this to for the function of their business. Also, business associates are permitted to, or may be permitted to, add in a provision to disclose PHI if the disclosure is required by law, if necessary for the proper management and administration. Also, another point of contention can be the provision of data aggregation services within the business associate agreement related to the healthcare operations of the covered entity. That can also be sort of a touchy point when negotiating these business associate agreements. And now we're going to discuss the hot topics surrounding these business associate agreements. Just to start off, overly expansive definitions. I like to sort of keep the definitions as close to HIPAA as possible, because the opposing party can add things that you're not expecting. For example, with the security incidents, as I mentioned earlier, you don't want to have to make a report every time there's a small ping on your system for an attempted breach, or someone's password is logged in incorrectly. Things of that nature could be overbearing for a lot of entities. The timing for breach notification can also be a testy one as well. As I mentioned earlier too, you want to be able to have some flexibility in investigating what happened. If you have a 24-hour turnaround, it's pretty difficult to have an investigation and to even determine if there's been a breach. So that's something where the covered entity and the business associate may differ, and there may be some room for negotiation. We also have breach notification and mitigation responsibility. Lots of times we see where the covered entity has a certain way that they want the breach notification to be delivered, how they want it to be drafted and whatnot, and that can be an issue if the covered entity has standard templates that they use across their business, and whether this may add to extra work for them.
And I will say too that actually technically under HIPAA, breach notification is the responsibility of the covered entity. So in some cases, they will delegate that down to the business associate, and that's kind of up to the business associate whether or not to accept that responsibility to make breach notifications, and even to pay the next bullet as payment for breach notifications and mitigation. But often business associates will push back on that and will say, we'll cooperate with you to get all the information together that we need to give notifications, and even we'll pay for the cost of it, but we're not going to take on the affirmative responsibility to provide the breach notifications to make sure they're done correctly in compliance with HIPAA, even if it's the business associate's actual fault at that point. So oftentimes the compromise ends up being, like I said, we'll help you, we'll even pay for the actual reasonable cost of it, but we're not going to take the delegation of that full responsibility.
Other hot topics include indemnity and limitations of liability. One of the things about being a business associate is that most of the indemnity rights seem to flow from the business associate up to the covered entity, because just the nature of these deals, the business associate is most at risk of having the breach that affects the covered entity, and not the other way around. But still, there's limitations that you're going to want to put on your liability. A lot of times we see that the limitations of liability are capped at the fees that the agreement, the underlying agreement, is on. We also have insurance is always a hot topic. Audit rights, as I mentioned before, you want to limit the ability of the covered entity, their ability of getting your books and just kind of keeping it to the provision of PHI.
So all of these things are, sorry, Edwin, I didn't mean to cut you off, but all of these things are essentially like the business associate, how much is the business associate willing to give to the covered entity that is not technically required under HIPAA. So things like requiring a business associate to have insurance, audit rights, giving them the right to cure a breach before the BAA is terminated. All of those things are, not rights that a covered entity necessarily has under HIPAA to put in a business associate agreement, and not necessarily obligations on the business associate under HIPAA, but they're just purely negotiated provisions that we see often in BAAs. And I will say, going back up to indemnity, one interesting point is that a lot of times it's very, very common to have indemnity in a BAA, and oftentimes business associates don't fight back on that. We just want to limit it as much as possible and make it reasonable. But when business associates do push back on indemnification, a lot of times we do go back to the fact that business associates are now directly liable to OCR under HIPAA for violations. So the argument there, if you're a business associate, is that if you're doing something wrong, or if you cause a breach and it's because you did not have the right procedures in place, OCR is going to come after the business associate directly and not after the covered entity for that liability now. So the covered entity doesn't really have that much exposure and that much liability. At least under HIPAA, we can get into a savvy covered entity will point out that there could still be state law issues potentially. You never know, depending on the state. But typically, you can take the position as a business associate that because of the revisions to HIPAA, you don't have that much exposure or liability. And as long as we're agreeing to pay for the cost of a breach that we cause, which is sort of a very limited form of indemnification, then that should be good enough for you, and we're not going to agree to provide a full indemnification provision. So we can really, that's one of the biggest hot topics, I would say, and we can really run the gamut from, big full indemnification provisions that the business associate doesn't mind, to completely refusing to include indemnification in any scenario in the BAA. And so, like I said, just going through all of these, does the business associate get the right to cure a breach of the BAA before the covered entity can terminate it? Edwin already touched on, can the covered entity have a say in whether the business associate's return or destruction of PHI is infeasible? All of the timing requirements are all negotiable. The covered entity has certain timing requirements under HIPAA for reporting breaches, for giving a patient or an individual access to PHI, for amending that PHI. All of these requirements, they're all on the covered entity, and HIPAA says the covered entity has to do these within a certain amount of time. What HIPAA does not say is when the business associate needs to get the required information to the covered entity in order for the covered entity to fill those out, to take care of all of those duties. And so, like Edwin said, from a business associate's perspective, you want as long as possible. From a covered entity's perspective, you want the shortest time possible so that you can get all of your ducks in a row as the covered entity within the HIPAA-defined amount of time that you have to do that. We talked about cloud service providers. Another way that covered entities can seek to get a little bit more control as well as having the right to approve any subcontractors that the business associate wants. So as we talked about, it's required that the BAA say if you use a subcontractor, you will enter into a subcontractor BAA with that vendor. But who gets to pick those vendors is not dictated by HIPAA. And so business associate would like to have control over that. A covered entity in some cases would like to know all of the subcontractors and entities and vendors that are having anything to do with its PHI. So that tends to be a heavily negotiated area if that pops up in a covered entities form. Then we get into state law requirements. So some people will take the position that HIPAA business associate agreement is what is required, and we just need to meet the HIPAA requirements. Anything else we agree on, and going beyond that is not appropriate. We don't need to get into state law. It's not a requirement under state law to have this contract. Let's keep it at what's the minimum that's required. Covered entities, of course, if they know that most of the individuals whose PHI they're in charge of or that they have are in a certain state, then they're going to want to squeeze in as much of that to the business associate agreement as they possibly can, because they want to have it in writing that the business associate will comply with all applicable laws. And you'll see in the last slide that there's a lot of other laws as well that covered entities will sometimes try to get in there. Encryption is, again, not required by HIPAA, but often covered entities will try to put that requirement on the BAA on the business associate, in the BAA. And sometimes business associates are fine with that because they use encryption, they meet all of the standards. It doesn't matter if it's in the contract or not. And some business associates would not like to have their security protocols dictated and controlled by the BAA where they would breach a contract if they don't meet it. And so you get two sides of that. Equitable relief. So can the covered entity automatically go to court and get an injunction if the business associate violates the BAA? As the business associate, you want to say, well, you can go try to get it, but you still have to prove your case, right? You still have to prove that you're entitled to injunctive relief, whereas the covered entity wants the BAA to say, we agree that we meet these elements that we're required to prove for injunctive relief, and therefore we can just go get that anytime we think you've breached it. There's a lot of talk right now about PHI outside the borders of the U.S. We have all of the new laws in Europe that are coming into play. So the parties will often disagree about whether the business associate should be entitled to offshore PHI and to use subcontractors that are outside of the U.S. and things like that. That tends to be a hot topic. HIPAA does not require any specific action with respect to subpoenas. So we actually don't see this in business associate agreements that much, but a covered entity often will like to know if their business associate gets a subpoena for their PHI. So that is something that as a covered, when we are negotiating on the covered entity side, we like to make sure that provision is in there, that the business associate will notify us on a very short, much shorter timing than a lot of the other timing requirements, say even like 48 hours, to notify the covered entity if there's a subpoena for PHI because of the nature of subpoenas, and you need to move quickly if you are going to take action to try to quash the subpoena or put a protective order into place or anything like that. Who gets to control litigation if there is litigation related to either the business associate services or use or disclosure of PHI that violates HIPAA? If we're getting under those indemnification provisions and there's an actual third-party claim, who gets to control that? Getting into amendments, a covered entity will often want to say, if we think there's a change in law or we think this BAA is no longer complying with HIPAA, we get to unilaterally amend it so that we can bring it into compliance and we can make sure that we are not going to be penalized or liable for having a BAA that's out of compliance. That is, of course, less appealing to a business associate who wants to have control over that and doesn't want new restrictions just imposed on it if they might be too onerous or might be something that could be negotiated a little bit. So that's another point of contention often. The question of who owns PHI is really interesting because there's no guidance under HIPAA. And of course, your gut instinct is to say the covered entity obviously owns it, and that is often in BAAs. The business associate has no right of ownership or anything to that PHI, and that doesn't make a huge difference except if the business associate needs, for example, to retain the PHI after termination of the BAA or something to that effect. Then you're going to want to add some language in there that explicitly permits whatever use you need of the PHI, despite the fact that the business associate does not, despite the fact that the BAA says the business associate does not technically own it, because that is not even a legal certainty at this point. Same with encryption. Anything that specifies particular IT requirements or security requirements. Some business associates don't want that in a contract. And then who has to provide notifications? We talked about this. And then as far as breach notifications, and then also notifying the secretary if the BAA cannot be terminated once it's breached. So the covered entity retains responsibility for breach notification and notification if the BAA cannot be terminated is not required any longer. So we've discussed all of those. One last slide on the hot topics, and then we'll kind of wrap this up. So survival clauses. What provisions of the business associate agreement are going to survive after termination? What's required to be in the BAA and will always be in there is that if the business associate retains PHI after termination of the BAA, then all of the provisions of the BAA continue to apply after termination, and the business associate must continue to protect that PHI. Beyond that, it's really about contract negotiation. If you agree to indemnification, almost always that will survive termination. But are there other requirements that you've negotiated within the BAA that you want to survive? And that does not necessarily just mean requirements on the business associate. That can also mean requirements of the covered entity. Oftentimes, covered entities like to include provisions that if they get to terminate the BAA, they also get to terminate the services agreements or any other agreements between the parties. And so business associates will often push back on that. We often advise business associates not to agree that they will comply with the covered entity's policies or procedures or really any control of a covered entity for their compliance, because you don't know what those say or how those might be amended, and they could very well go beyond the HIPAA requirements for a business associate, and you're suddenly stuck complying with somebody else's more strict policies and procedures. The last specific point is, will the covered entity be required to comply with the minimum necessary rule, which says that you have to use or disclose only the minimum necessary PHI to achieve the purpose that you're going for. That's a requirement technically on a business associate that's often included in BAAs. However, covered entities are also required to comply with the minimum necessary rule under HIPAA. So sometimes a business associate wants to get that explicitly in the contract, primarily because they want to ensure that the covered entity does not disclose a ton of extra PHI to the business associate that is not necessary, that goes way beyond what's needed. And then the business associate is suddenly liable for 2, 3, 10 times as much PHI, and protecting that PHI as they would otherwise be if it were limited to the actual minimum necessary. So the covered entity is required to do it anyway. Sometimes a business associate feels better if it's actually in the contract. And then there are just 3 types of rules here. These are all federal rules. 42 CFR Part 2 deals with substance abuse information, and then the Graham-Leach-Bliley Act and the red flag rules are more kind of financial and consumer rules. And sometimes those pop up in BAAs, and they don't really belong there. A covered entity might take the position that we want to get all of our privacy, all our agreements to comply with all of the privacy rules, anything that could possibly apply. We want it all in one document in the BAA. And that's fine if the business associate wants to agree to that. Often these aren't applicable, and we, as a business associate, would take the position that we need to keep this to HIPAA. And any of these types of laws should be included in the underlying services agreement. And then finally, we have shenanigans. So it's just a catch-all for anything that's kind of funny in a BAA, and you likely want to question it, discuss it, maybe consult your legal counsel. So as you can see, all of these hot topics are things that are not necessarily required or even addressed at all in HIPAA, and it really comes down to how much control is the covered entity going to have, and how much risk and liability are they going to negotiate away onto the business associate versus how much independence does the business associate need, and how much risk and liability is the business associate willing to take on beyond what is actually required of the business associate under HIPAA. So I know that we're out of time, but I think you all will get these slides and you can look through. That was our main topic, was negotiating business associate agreements, and the rest are just kind of interesting tidbits about litigation or settlement actions with OCR that did actually involve business associates, which didn't happen for a long time and has just been getting started in the last couple of years. So OCR is really making it clear that that they will come after business associates, and they will come after covered entities for not having business associate agreements in place. There's actually, you'll see in the slides, there was actually a settlement related to that where a covered entity didn't have a BA in place where it should have. So these issues are getting a little more intense and just a little more important in the overall spectrum of HIPAA liability. So with that, I know we're 1 minute over. We will go and conclude. I want to thank everybody for attending, and I'm just going to click through. So our contact information is here. Please feel free to reach out if you have any questions, further questions. I know there are some unanswered questions in the webinar, so we will get back to you on those shortly. And again, thanks for attending, and let us know if we can ever do anything to help you all with your HIPAA compliance.